Hi, and welcome to another edition of the Trustcast show. And we're really happy to have with us Jeffrey Liggio today, who has a really interesting background. Welcome to the show, Jeff. Or do you first Jeffrey or Jeff?
It's either one, and it's Liggio, Liggio.
Liggio. Okay, I got it. So, welcome to the show.
Pleasure to be here.
So, Jeff or Jeffrey flew helicopter rescue missions for the Air Force for 25 years. Actually, retired. He went to night school while he was in the Air Force, and then worked as a reserve Air Force officer, and and then during that period of time, he worked rescuing Florida families from insurance companies that told them no. So tell me, Jeff, what was the connection between search and rescue in a helicopter and search and rescue in a courtroom?
Well, that's an interesting question. First of all, I want you to know that when I first became a lawyer, I had in my mind, because I'd been a Navy helicopter pilot first, that I was going to be a plane crash lawyer or a maritime disaster lawyer, and that's what my goal was. And the first job I had, the appellate lawyer of the firm said, you're a smart kid, and there aren't many plaintiff lawyers who understand insurance, and you're going to learn insurance law. I didn't want to do that. I want to be a plane crash lawyer. So he and my boss at the time, and you understand this was a long time ago. Every night when I had to take home some sort of cockamamie insurance policy or insurance question. There was no internet then. There was none of that stuff. And read it and come up with an answer. And the next morning, if I didn't get it right, they would dock my pay. So I sort of learned in a force-fed thing, but it ended up being a wonderful career choice because they were right. There just wasn't anybody or hardly anybody that did it then. And then over the years, people would send me various types of insurance disputes. Some of them are minor, some of them are simple. They could be, not a bad faith, real egregious case, but it could be we don't want to pay the benefits, or we don't want to pay enough, or we got to cancel, or you didn't tell us this in the application, or all sorts of things. And it became a steady part of my practice, and over the years, more and more so. And then with that happening, we ended up representing folks when they've been guilty of when the insurance company had acted in a bad faith or a breach of fiduciary duty situation. And we've also had an opportunity to do some class action work against insurance companies. So ended up being from them force feeding me insurance to being a career, a very successful career. And the parallel is when you go out in a helicopter and looking for somebody lost at sea, for instance, or on a mountainside, or they had a heart attack on a cruise ship. We had a few of those over the years. They had nowhere else to turn. Despite the weather, despite the conditions, despite all other factors, their life depends on that helicopter and the crew to bring them to safety and to get them the care that they need. So people come to me and have come to me over the years with insurance disputes, and they have nowhere else to turn. For instance, in a health insurance situation, some people say I have great health insurance, and I'm sure you do, but you never know you don't until you are fighting a life-threatening illness or situation for you and your family. And now you have to fight the insurance company at the same time. So, like I said, people come to me now and over the years in the insurance practice because they're in a real threatening situation and they have nowhere else to turn.
So, if I just got a letter from, I'm going to ask some hypothetical questions, and then we're just going to kind of riff. So, if I just got a letter for denying my health insurance claim, is that the end of it, or do I actually have options? Because this happens all the time. People go in, they think I'm covered, but the insurance companies no.
You have options. There's it gets a little more complicated. Where did you get the insurance? If the insurance is a benefit of you working for a private enterprise, then that insurance is subject to the federal ERISA law. And we'll talk about that in a moment. If for instance, someone is a Medicare beneficiary, even if they have a Medicare Advantage plan, there's a different set of procedures that may apply there. If someone has health insurance, for instance, I'll talk about health insurance because that was the question. Health insurance, and they work for a state governmental entity. There are procedures that apply there, and of course, if someone has a an Affordable Care Act plan, an Obamacare Act plan, there are terrific remedies. So the first thing is in that denial, they're gonna the insurance company is going to tell you what you need to do to appeal it. And between that process and the appeal procedures that should be in every health insurance policy, that has to be the first thing. Now, if you don't have time, if it's a denial of a frightfully expensive, for instance, a chemotherapy drug, you got to go right to a lawyer, and the lawyer may perhaps will be seeking an injunction. But there is always an ability to fight back, and what we've seen quite often is, the insurer will not follow the law of the state when they're denying a claim. For instance, we've got one right now where a very sweet young lady had a baby, and they added her baby to the policy, and then she was able to get insurance elsewhere, so she kept the insurance for her baby. Well, while the policy was in force, she had some postpartum complications, and she was in the hospital for over 20 days for a six-figure medical bill. And the insurance company decided they didn't want to pay, and they did a post facto cancellation of the entire policy like 120 days after she added the baby. Well, we were in Florida. There's a Florida statute that says you can't do an ex post facto or a related back, if you will, cancellation beyond 90 days. So the cancellation was a nullity. She wouldn't know that. There's nothing in the paperwork would know that. That's why they come to us. And of course, the insurance company, they didn't look at the statutes. They just denied the claim.
So, there are a couple of things I picked up out of there. So, the appeal. I talked to another attorney once about the appeal and the possibility of making a mistake on the appeal if you're filling this out yourself, and how you can screw yourself out of your rights and um, your ability to pursue a claim because you filed the appeal in a certain way. Can you speak to that?
Yes. And we mentioned, and I'm glad you brought it up, we mentioned in the ERISA context that may also apply in some of the Medicare situations. In an ERISA claim where the insurance is a benefit of private employment, you have to exhaust the administrative remedies in their entirety before you could ever go to a courthouse. And then the only courthouse you could go to would be a federal court, no jury trial, and the judge has a criteria to utilize as to whether the insurance company acted in an arbitrary or capricious fashion. So it's a trap for the unwary, and the only record the judge looks at is that internal appeal record. In other words, you're not out there discovering, taking new depositions, it's crazy. So filling out that paperwork, it being over detailed is vitally important. And people sometimes are going to have to go to a lawyer, especially if it's a complicated situation, and say, "Can you help me? Help me to do this administrative appeal." Now, the dilemma is there's no court awarded attorney's fee right there. So quite often folks have to do that. Now they're fighting the insurance company. Now they're fighting a health situation. Now they got to pay for a lawyer. So it's not an easy situation.
Okay. So, a lot of your practice, I imagine, is on contingency, but in those cases, then it would be, on a straight up fee. Is that right?
Yes and no. They're almost all
Okay.
on they're almost all on a contingency.
Hmm.
And for certain types of insurance, there are court-awarded attorney's fee statutes. So if there's a statutory fee, the way this fee works is the fee would be a percentage, whatever is saved or what is obtained, as opposed to a court-awarded fee. And if the court-awarded fee is greater, the client doesn't pay a fee at all. The lawyers just get the court-awarded fee. If the court-awarded fee is less than a percentage, you have to credit whatever the court-awarded fee is against the percentage, so that's a greatly reduced fee. And the nice part of that, because they're court-awarded fees, is somebody with somebody with a relatively small insurance dispute can oftentimes hire a lawyer and be able to not have to pay the attorney's a fee. And it also is good for us on a mercenary basis that we could take a smaller case and hope that we can get paid for our time and effort.
Oh, right. So that makes sense. So that can kind of dissuade, I would think, but maybe not, insurance companies from doing things that are maybe they shouldn't be doing.
I wish I could say that happened all the time. I mean, oh my goodness, this guy Liggio is representing this person. We better reconsider this. It happens occasionally, but generally, and you understand something that big corporations like insurance companies don't think that they are exempt from we gotta protect Jane or Johnny over here. They made this decision, but they're a good person and we gotta protect them. It's not necessarily a money decision when they defend a lawsuit. It's the craziest thing you've ever seen.
So I'm going to jump around a little bit here because something you said just brought up this question I had written down for later. Florida recently gutted the law that used to force insurance companies to pay your attorney's fees when they lost. What does that change actually mean for someone with a denied claim right now?
Again, there are still in certain areas of law, there are some court awarded fee statutes still. Number one, if there is a total denial of the coverage, not an inadequate claim. Under Florida law, the insured can bring a declaratory action and still seek an attorney's fee. If there is an HMO, if it's a health insurance situation, there's an HMO attorney's fee statute that was not repealed. For someone who is insured under a Florida group, a Florida contract, but a Florida group health insurance situation, there's a group health insurance statute that was not repealed. So there still are some statutory attorney's fee remedies. And other than that, it's unfortunate. There is a way to still get some court awarded fees, and I have to give you an example. Okay,
Yep.
uh,
Examples are good.
when I was a young puppy of a lawyer, I represented a fellow, and there was a denied insurance claim, and it turned out the insurance agent had screwed up when they got the new policy, and the agent's lawyer and the agent's insurance companies fought us literally like dogs. And we had this one judge who I was not that judge's favorite. He liked that young fella from that represented the insurance agency, and we had a jury trial, and the jury gave us a verdict, and then the judge took it away, and we had to take it to the appellate court and get it reversed. Fast forward 30 years. I have a young associate who just gone to work for me, and someone comes in and there's an insurance agency problem, and I'll be damned, it's the same judge and it's the same lawyer on the other side. And I think the client was owed, I think his losses were about $125,000. And I told the client, because you can't get in a court awarded attorney's fee against the agent, but this is what you do. So I knew that this lawyer was not going to settle. I knew the insurance agency was going to settle, and I knew this was not going to be a pleasant experience in front of this particular judge. A perfect training experience for my young lawyer. I said, I'm going to hand it to my young lawyer, but I will only take your case if you will allow me to do something called, called either, I'm sorry, a proposal for settlement or an offer of judgment. They use different phraseology under a Florida statute and a Florida rule of procedure. And what happens is you demand a certain sum of money and they have 30 days to pay it and enter the judgment. And if they don't, if you go to trial and you get a verdict of 125% of that number, you get your attorney's fees from that 30 days on. So I went to the client. I said, "You're going to give me the authority to do a proposal for settlement for $50,000." What, are you kidding me? Crazy? My loss 125,000. They're not going to take it. We did it. They didn't take it. My young associate litigated the case. He tried the case. He got a verdict. The judge and the judge, based on this other lawyer's motion, took it away. It went to the appellate court. We got it reversed. The client got every penny of his money with all the statutory interest, and I think we ended up earning about a 300 and some $1,000 fee. So using that story, if someone has a significant health insurance case, quite often I will say to them, I can only take your case now if you will give me the authority to do a proposal for settlement. And we pick a number that we feel very certain that we are going to beat once we prevail in the lawsuit. So that's another way perhaps to get a court awarded attorney's fee and for that person to afford a lawyer that they otherwise couldn't afford. A long story to get
Interesting.
to a short answer.
No, no, an interesting story. So you said you mentioned earlier Medicare Advantage plan. Is there some difference in the way those are handled from a legal perspective as opposed to a regular Medicare?
No, it's very similar. It is very, very similar. They invoke the Medicare protections, so when there's a denial of a claim in Medicare, there is a federal administrative process. And there are certain ways that you can bring those cases to court, but it's not easy. I frankly, and as a senior citizens, I advise any senior citizen that comes to get me, don't get one of these cockamamie plans because they're going to pay for your gym membership. You get Medicare and a supplement. You have, if there's a problem, far greater rights.
So as I understand it, once you sign up for a Medicare Advantage plan, then you can't change back to the regular Medicare plan. Is that right?
Not, I'm not so sure. I'm not so sure what the rules, whether you can just drop it and go with straight Medicare. But I know there's an annual re-enrollment at any rate, so you may be stuck for a year. I'm just not sure how that works. And I
Oh,
don't
okay.
give that information.
So my insurance is telling me to try and fail at a cheaper treatment, even if they know it's not going to work, before they'll approve what my doctor actually prescribed. Is that even legal?
It's called they've named it. They call it step therapy. And is it legal? I think it's horrendous. But for instance, there's a Florida statute that applies to every health insurance company in Florida that says that you have to have a protocol. If someone says, I already tried these medications, they don't work, I need to stay on the medication I'm on. And they have to post it on their website. And of course, most of them do not do that. I'll give you an example. I had a very nice young man who had terrible digestive problems. He ended up losing a lot of his plumbing. And he switched Obamacare plans from one to the next. And before he did so, he wanted to make sure that his doctor was on the plan. And of course, they said his doctor was. He gives him the money. He's got the new plan. Goes to the doctor. I don't take this insurance. Oh, go to Doctor So and so. Oh, we can't. We're not going to approve that therapy or that medication. Now we're going to have to approve something less. And in the step therapy process, he ended up having very, very severe problems. And so, is it legal? Maybe, but there again, It's not something, if you have a serious, serious problem, it's not something you want to wait and fight.
Wow. So ultimately, in that, I mean, it seems like morally they're liable. Were they found to be liable in that particular instance?
They resolved the matter before we got to the point that generally with cases like that, they try to resolve the matter before they do. We do have an ongoing case right now with a governmental plan where they tried that stuff, and we have a hearing on summary judgment motions next month.
So what's the difference between my insurance company being slow and them acting in bad faith?
Well, slow again is there are, I believe, in every state in the union. There certainly are in Florida. There are statutes that give certain time frames in which they say how providers or the insureds are supposed to communicate claims and how long they have to resolve claims and all the appeal processes, and the providers can't contract around it, and the providers can only go after the insured after they the insured patient after they've exhausted the administrative remedies. So it's not just slow; it may be violations of the statutes. And again, I keep talking about the statutes because I found, I hate to say it over the years, there's a lot of lawyers who are lawyers that don't read the statute. So
So how do
slow,
I know?
slow could be a statutory violation. Well,
Okay.
if it were me and they were slow, I'd be looking in the state that you're in for something called the prompt payment statute. There's a Medicare prompt payment statute. So slow and what the statute requires are two different things. Now, bad faith is basically to put it simply, all insurance companies have a fiduciary obligation to their insured. We pay them money to get the protection that they provide. And under the law, they're supposed to put your interests before their own, before their monetary interests, when there's an issue. If there's a question in interpreting their own policy or their contract that they drafted and they imposed, that question is always supposed to be resolved in favor of the insured. Now, in Florida, in that type of situation, because this is what is called the first party situation, that's the relationship between the insurance company and the insured. There's a statutory notice form that's called the civil remedy notice, and it's filed, and it's a certain process. And you can look it up. You can look up on the internet the Florida Civil Remedy Notice. And it even has a search function. For instance, you could search, I guess you could search my name to see how many civil remedy notices we filed over the years. When we have an insurance adjuster who we suspect is not a one-time offender, we can search to see how many times folks had complained about that insurance adjuster. So there are those statutory remedies, and again, it's the statute. The basic bad faith statute is you didn't settle with your insured when you knew of it, you should have, when you should have, and you had the information. And then there are other statutes that define, as a public policy of the state, what are called deceptive and unfair trade practices. And those are it's a wider range of them that deal in the sale of insurance, deal with the underwriting of insurance, and most importantly for this discussion, deal with how claims are supposed to be handled. For instance, in an automobile or a property and casualty situation, there is a statute that says it is a deceptive and unfair trade practice to try to negotiate with someone who's in severe emotional or physical distress from a collision or an accident.
So what's the remedy if an insurance company does that? Because I know this happens all the time. What is the actual remedy? So an insurance company, runs to your bedside and wants to negotiate, hey, we've got a settlement for you. What do you do?
Two things. Number one, file a lawsuit. They will defend, claiming there was a settlement, and you'll litigate whether there was a settlement in that lawsuit because it's a two two-step process, at least in Florida. You have to win the lawsuit from the underlying situation. Either you got to get the benefits of the policy and or you got to get a verdict based on the damages caused by the other driver. If that verdict is in excess of the insurance policy, then there's lawsuit number two, the bad faith lawsuit, for their basic, as I said, violation of their fiduciary responsibility. And there can be other damages assigned as a result of that bad faith conduct.
How often does that happen?
Often enough, I mean, we have one right now that it stayed while they appeal the underlying case. But I have the ultimate sort of parent's nightmare. Their 60-year-old gets her license and then she causes an accident very shortly thereafter. And the insurance company that remember in an automobile situation, you give the insurance company obviously your premiums, and in the contract, they retain the right to determine how whether they're going to settle it, how we're going to litigate it. It's all their decision making. So if they don't pay the excuse me, settle the matter within the policy limits, now the insured is stuck with what is called an excess verdict. So here we have a case where the litigation went on for 2.5 years, and the lawyer for the person who was injured in the accident kept saying, "Pay the money, pay 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 the money." And the insurance company did not. Now this young girl starting out her life who had a medium sort of rear end collision has a $5 million judgment hanging over her head. She can't rent an apartment. She can't get credit. I mean, think about it.
Mm-hmm.
So we filed a lawsuit and we're going to go after the insurance company.
Interesting, but sad.
Yeah.
So, my health care plan, what if they say, we're just administrator. We have a third party, that handles, this, and it's not really our decision. They made the decision. How do you handle that sort of situation?
Okay. These go to this situation goes to basic agency principles. If I have a contract with you and you go ahead and subcontract to somebody else, you're on the hook for the subcontract. You can't you're not insulated from that. So the fact that it's some independent review company means it's it's meaningless because your contract is between you and the health insurance company. Now you're gonna have to litigate it, sure. And it's funny, we've had a chance over the years to litigate against so many of these health insurance companies where they send it out to what is quote unquote an independent review. And you can go online and look for these independent review companies. And it's basically a doctor who is generally moonlighting on the side for a couple $100. And they basically feed him what to say. And we've even had some over the years where the doctor says one thing and then they change the report before it goes to the insurance company.
Hmm.
It's crazy.
Wow.
It's
So,
institutional fraud when they do that.
so that would trigger the bad faith.
It would trigger bad faith, but also before you get to bad faith or in lieu of bad faith. Remember, I said the insurance company has a fiduciary obligation to the insured. It may lead to a breach of fiduciary duty, a claim against the insurance company. And also, if they promised you the sun and the moon and the stars when they sold you the policy in the first place, that you relied on to get this policy, it may also lead to a fraud and inducement action because of what the promises they made and never intended. to comply with just to get your money.
So if my claim was denied, how do I know if it's worth fighting or if I should just cut my losses?
It depends on why it was denied. It depends on maybe what your doctors or providers say, how they advise you. And it never hurts to do some internet research. We've had situations. I remember a few years ago during COVID, we had a very unfortunate man, a lovely man, who had a terrible heart condition, an arrhythmia type of situation in his 40s. And the drugs weren't working, and his doctor recommended that he have one of those Watchman devices implanted. I'm sure you might have seen them advertised on cable news over the years, a Watchman device. And what it does is put it a certain place in the heart, and it'll sense that a stroke is coming. It'll literally close up that part of the heart. That's what it does. And this gentleman's doctor recommended the Watchman device. And the Watchman device had already been approved by the FDA and approved by Medicare. Now, why is that important? Because in the Medicare and FDA statutes, they are statutorily not allowed to approve an experimental drug or a medical device. If they approve it, it ain't experimental as a matter of law. Well, not to this administrator insurance policy. This fellow worked for one of the Florida governmental entities, and he didn't lawyer up. They did multiple appeals. His doctor did multiple appeals for over a year, and then he finally had a stroke and had severe problems and came to us. And then we went after them for their conduct. So how do you know? You do your research. You get you try to determine it as best you can as a layperson, and then you may have to pick up the phone and call a lawyer.
Okay, so I'm thinking about this as so I'm in a situation. I mean I'm not, but hypothetically I'm in a situation, and then I'm thinking, well, crap, I don't know what to do, but I can't afford a lawyer on top of everything else. How does this actually work?
Well, the one bone that I don't have is the mercenary bone. I joke about it. I don't think about the dimes and the pennies coming in. And most of the good lawyers are of my ilk when it comes to that. You contact a lawyer who you think has experience and ask if they will take a look at the matter. There will generally never be a charge to review something to determine if there's something we should go further with. So don't not try to talk to a lawyer because you're going to think it's the first. I've got to pay some money before I even open my mouth. But in doing that, you want to gather the documents. Nowadays with our electronic way that we communicate, we'll tell the clients, give us all the documents with a PDF front and back, and we'll take a look at them and we'll let you know. Um, and because we're a small firm now. I use the fish market analogy. People come to me. I say, "Listen, I got to tell you something. I know it's a rush for you, but this is like coming to the fish market. You take a number and you take your turn. I'll get to you as fast as I can." But we're blunt and open and honest about that, and that's what you should expect. So again, going back to the question, don't not consult with a lawyer because you think it's going to be the clock is ticking the minute you contact them. Don't do that. Contact them and see if they'll take a look at it.
So if I'm in this situation where I feel like I can't afford a lawyer, or I want somebody to look at this, the tendency of a lot of people is just to call up the lawyer that they've had for other things in their life, the insurance, or the an automobile accident, or their house closing, or what, just their general practice lawyer. How do I know? What should I look for if I have this kind of situation,
Well,
in a lawyer when I'm looking for a lawyer?
there's a lot of lawyers. For instance, it's a great question. There are a lot of lawyers that say they handle insurance disputes, but they're not descriptive. So in the internet search, you should be looking for health, health insurance, managed care, dispute lawyers. Um, there is no national organization that does this. There are a couple of great public interest organizations that do deal with health insurance type of situations, and they may be able to put you in touch with a lawyer. There's one out in the West Coast that I get the newsletter from, and I don't even know them, but I'm impressed by the newsletter, and it's called the Arm and a Leg Show. And there are some other ones. So again, a lot of this nowadays calls for some real internet research, but also the code of ethics for all lawyers mandates that if we don't handle a particular type of dispute, we must disclose that to the client. So the inquiry, if you talk to the lawyer that, maybe did your house closing, for instance, I have a health insurance situation. Do you handle this kind of cases? Can you maybe give me a recommendation to someone that you know that is good? That's we get them a lot.
So if the insurance companies offers me a quick settlement and I kind of need the cash, should I take it or is that really a red flag?
Well, we never get into, and we should not get into, trying to find out what's going on with people's lives. What people need right away. I will tell you that I'm any time like that situation where there's an automobile accident, and the adjuster is knocking on the door and say, "Here, I give you about $2,500 or $3,000 for your medical bills. You just sign it right here." That's a red herring. That's too good to be true. And it's always better if that happens to maybe slow down a little bit. That would be the time to pick up and talk to the lawyer that you know. Doesn't take long, you know, doesn't take long.
So you spent your whole career going up against companies with unlimited lawyers and unlimited cash. What actually levels the playing field, for your specific clients?
Um, Attitude. Um, in order to do what I've done for 44 years successfully, and I will tell you, and I tell every client, I do not win all my cases. If you go to a lawyer or you look at their website and they're winning for everybody and they've never lost and they're the greatest thing since sliced bread, they're either afraid to go to the courtroom and wait for the jury to knock on the door, or they exaggerate their accomplishments, or they're lying. So, we have the attitude that we are extremely aggressive in our investigation and our evaluation of cases before we ever take them. But then once we take them, we know we're going to be outnumbered, we're going to be outgunned, we're going to be out financed, but they're not going to work as hard as we are, and they're not going to strategize the way that we do. Now, what do I mean by that? The difference, if you're handling a particular issue, just like in the military, right? If there's a particular issue on a particular moment, how you handle that is called a tactic. Where you want to start the whole effort from and where you want to end up, that plan is called the strategy. And we're different that we have a strategy. Everything we do in a lawsuit, everything we do representing a client is in support of the strategy. All the discovery, all the depositions, all the questioning is in support of the strategy. And I found over the years that these big companies with their big fancy law firms, they are purely tactical. There's no strategy.
Interesting. So if somebody's listening to this and they do have an issue, and they're in Florida. Do you practice anywhere else?
Just Florida. Florida in the federal
Okay.
court.
Then how do they get in touch with you?
I'm on the internet. Give me a call. Look for the website. The website is it's basically my name, www.liggiolaw.com. And I'm Jeff Liggio. I'm the chief cook and bottle washer still after all these years. And I'm lucky. I'm very lucky. I have a over the years we were a bigger firm at times and a smaller firm at times. But now at this stage of my career and my life, I have three supervisors who have been with me forever. My paralegal is a wonderful woman named Kathy Harmon, and she's been working with me since 1997. And my office manager is Sharon Allen, and Sharon's been my office manager for going on 20 years. And our other paralegal and my legal assistant, her mom was my office manager for 25 years and paralegal. And I used to drive her to school. And now she's working with me for almost 20 years. And but it's almost like being the head of the family. And they're very protective of me. I'm very protective of them. I'll give you an example. Years and years ago, I decided I was not going to put up with rude and difficult clients. And if a client is nasty or rude with one of the office staff, I don't care how big their case is. I don't care what it is. They have a conversation with me, and it's one of those conversations with you, which is, now I'm going to talk and you're going to listen. And they're told, I better never hear of it again, and you're going to take your case and go. And the only answer is, yes, Mr. Liggio, I will. Thank you. So because of that, I protected them and they protect me. And I got a few years left.
That's a great story, Jeff. Thanks for coming on the show.
Pleasure. It really is a pleasure, Zane. Thank you.